Good afternoon, Mr. Aina. I think we are in a position to resume. Thank you.
Thank you very much, my Lord. My Lord, I'm very anxious to answer the question of Lord Stevens before we broke. Could I just therefore ask my Lords to note the ninth the ninth point? The reference is page 1129, line 29, which is the ninth evidential reference in the closing speech, where the advocate was seeking to deal with the diminished responsibility issue evidentially before the jury. My Lord Stevens' question is a fundamental one. It is a question that suggests that there was no cross-examination on substantial impairment, because had there been cross-examination on substantial impairment, the problem would not have arisen. With the greatest of respect to my Lord, if the issue of substantial impairment at the end of examination in chief had not been raised, there would have been no need for cross-examination at all by prosecuting counsel. So I just wish to show my Lord very briefly that the issue of substantial impairment had been raised, which is the reason why prosecuting counsel had to cross-examine on it, but without actually using the word substantial impairment. So if I could invite my Lords to turn back to the passage we've already seen at page 933 of the bundle, which is the central issue in this appeal. At line 10, if I can start from there, please. This is after the discussion with the judge in chambers. I'll come back to that later on. And we're now back into open court. And at line 6, the advocate says we'll need to take this quite slowly. But first of all, what comment would you make in relation to whether or not there is an abnormality of the mind, bearing in mind the section that I've just read to you? And so it's worth reminding my Lords that the witness, the expert, had that section read out to them, section 22A. And so in answering at line 10, the witness says and sets out that the mental abnormality would include mental illness, and sets out that the defendant falls within the necessary classification. And then at line 19, the advocate asks, again, in relation to Mr. Anderson, was that abnormality present at the time of the killing? And of course, this is the crucial question for the jury. And I think that line 21, that's an error on the transcript. It's quite clear that line 21 is the witness who's answering that question. So could I just ask my Lords to take note of that? It's the witness who then answers, saying personality disorder is a pervasive condition. And that was the reason why I started with that terminology at my opening remarks. It develops over a period of time, and it is accepted that the personality is fully developed by mid-20s. And once a person has a personality disorder, that is a pervasive illness or a pervasive disorder with no remissions or relapses. So in answer to the question, it is my opinion that at the time of the killing, Mr. Anderson would have still been suffering from a personality disorder. So that's step one in front of the jury. It is there on the night of the killing. And then the advocate goes to step 2. The phrase then is substantially impaired his mental responsibility for his acts and omissions in doing or being a party to the killing. So if we can concentrate on the words as substantially impaired his mental responsibility, what are your conclusions in relation to that? And the witness answers, in my opinion, the personality disorder has a direct link to the violence and would have impaired his mental responsibility. So we pause there. The witness is saying to the jury In my opinion, this serious illness, which is established, has a direct link to the violence and would, not could, would have impaired his mental responsibility. Whether that impairment was substantial or not, I would not be able to comment on that. That would be for the respected jury. So pausing there, what the witness is saying to the jury is, I as an expert take the view that there is a direct link between the violence and the mental illness, and it would have impaired his mental responsibilities. Up to you whether you go on and make the final decision about the matter, which is, as we all know, always a matter for the jury. And then the advocate continues. In relation to the personality disorder, however, are you able to make comment on its degree? And the witness says, Mr. Anderson fulfills the criteria for personality disorder. And in my opinion, on a balance of probability, it could be classed as a severe personality disorder. And then this is the important part, considering the impact it has had on his functioning and lifestyle over the years. So what the expert is saying to the jury, this isn't some trivial illness that comes in and out from time to time. The expert's saying to the jury, this is a serious illness and it's had an impact throughout his life. In other words, it's pervasive. And so a jury could have found diminished responsibility based on that evidence. And that's the reason why prosecuting counsel had to cross-examine on it. They couldn't leave it. If my lord were right, then prosecution counsel did not have to cross-examine, but they did have to cross-examine because those words had the potential impact on a jury of finding substantial impairment. And so when we then come, if I may take my lords, please, to the written case, because this is probably the quickest way of dealing with this point. If my lords turn, please, to page 1539, page 1539 of the bundle, you'll come to the respondent's written case. And you'll see that at paragraph 27, the last sentence, I addressed the matter that Lord Stevens was asking me about, the direct question. Dr. Puri was also cross-examined in detail and made reference to the appellant's significant mental impairment operating at the time of the killing. And there's a large passage of 936 to 992. And what I seek to do is, to save my lords having to plough through all that, is to pick out, to cherry pick the best bit. So that's what I then go on to do. So, for example, in cross-examination, Dr. Puri gave answers suggesting there had been a substantial impairment across the appellant's life, the very issue which the jury had to decide on diminished responsibility. And so Dr. Puri's asked questions about the Blue Book section on personality disorders, and he sets out what that means in the context of this case. These types of conditions comprise deeply ingrained and enduring behavior patterns, manifesting themselves as inflexible responses to a broad range of personal and social situations. And prosecution counsel asks, well, what about Mr. Anderson's history, which represents extreme or significant deviations from the way the average individual behaves? Because that's what the jury want to know. And the answer from Dr. Puri, that it is the presentation across the whole of his early years and adulthood, which actually is quite significantly driven by and impacted by his underlying personality disorder. And so prosecution counsel continues, she cites the Blue Book of how severe the illness must be in order for it to have the impact, the substantial impact that the jury are concerned with. And she asked the question, what is the severe disturbance in Mr. Anderson's case? So she's trying to deal with the topic without using the word substantial. And the witness answered, well, again, the different changes to jobs, the conflicts on the basis of which he changed these jobs, his long-standing difficulties in his marriage, his ambivalent interactions and relationships with those around him, his lack of any lasting, meaningful attachment, either with his family or his peers or colleagues over the years, the lack of any one stable, confiding relationship there, including with the wife of many years. And he says that it had established itself with him by the time he was 25, and it remains for life. And then the prosecution counsel asked, are you able to say what his personality disorder was on the night of the 30th of November to the 1st of December 2013? Dr. Curie, it's a pervasive underlying disorder that he had had for years, which was present on that day, which you would expect to be present on that day, because you do not expect, or there are no remissions and relapses in personality disorder, and therefore would have directly impacted his behaviours on that particular day as they would have done on any other day. So just pausing there, the doctor's given the information to the jury that they can find that there's a substantial impairment by his answers. Prosecution counsel continues on that crucial theme. So what was the real cause of his conduct that night? Dr. Curie, I can only comment on what could have been the contributory factors to his conduct on that night. And in my opinion, his personality disorder and the fact that he was exhibiting morbid jealousy in the lead up to that period of time, I believe that these would have been important and those would have potentially contributed. Now that's the language of the doctor, potentially contributed. That's how far he was prepared to go with the jury. So a straightforward question. And then he goes, and he had finally had confessions from both Mrs. Anderson and Mr. Roberts, which in my view is quite significant. And then the prosecuting counsel continues to ask these important questions. A marked tendency to act unexpectedly and without consideration of the consequences. What about his behavior is marked? Haven't the incidents been intermittent where he has acted unexpectedly? And then Dr. Curie refers to the incident in July when the police are called, and he gives examples to support what he's trying to say to the jury. Prosecution said, well, that's intermittent behavior, that's not marked. And Dr. Curie said they might be intermittent, but they are still marked, they are still significant. So he's saying to the jury, in my opinion, this is my opinion, it's significant. That's the weight that you attach to it. And prosecution counsel continues, a marked tendency to quarrelsome behaviour and conflicts with others, especially when impulsive act is thwarted or criticised. Again, I suggest to you that that isn't a marked tendency. It's not a frequent or a marked occurrence. And Dr. Curie says, if you look at all the incidents of conflict in his workplace, his marriage, at the wedding, he's exhibited a tendency to be involved in that conflict. And it has either escalated or he has been quarrelsome. And then this, I believe that because it's over lifespan and because it's in so many different domains, it is a significant or marked tendency to be quarrelsome. And this continues. It continues, my lord, over the page, if I could just take you to the top of page 1542. Dr. Curie says, if you look at it in his personal relationship at the wedding, if you look at it with his boss at work, if you look at it with Mr. Roberts, if you look at it with his wife, I cannot understand why it wouldn't be considered pervasive or across the domains, and therefore not significant or marked. So he is, as I've said in this document, he is saying to the jury, it is significant. But what, as my Lord Stevens has quite rightly said, prosecuting counsel did not do, and would not be worth her salt if she had, is that she never uses the word substantial impairment. What she does is she deals with the substance of what the doctor is saying, not the label. And so I hope, my Lord, I've answered the question that the issue was before the jury, both in examination in chief and in cross-examination. And what I'd like to do, if I may, is just to deal now with why the expert, whether the Dukester was writing his approach to the expert, because substantial criticism is made of counsel at court and of the Deemster and of the appeal court in relation to how this issue was dealt with. Now, my lords, I don't need to take you back to page 931 because you've seen what took place in front of the Deemster in the absence of the jury. But it's worth just going back, if I may, please, to, I'll just give you a moment so I get the correct reference. Yes, okay. Yeah, so if my lords go back, please, to, I think, page 928. We start from there. At line 30, please. The defence advocate starts by saying, I'm quite happy for Dr. Puri to be here. I'm conscious that I'm about to go into the section of the criminal code that outline diminished responsibility and provocation. And so may I pause there, my lord, and make this observation, which my lords will either have to agree with or not disagree with. There are only two reasons in a criminal trial for calling a psychiatric expert. One is to establish that there's a mental illness, and the second is the impact that illness has on the tribunal of fact. And it doesn't matter if the tribunal of fact is the jury or the tribunal of fact is a judge when sentencing. It's the same thing. The expert is called, one, to establish the illness, and then secondly, if it's a jury, the impact the illness had. If it's a judge, the impact the illness had for the purposes of sentencing. That's the whole purpose of calling the expert. And this wasn't a young lad who was on his first outing in the court. As we've seen, he was a very experienced expert from Rampton High Security Hospital in England. He knows why he's being called. And so when in the absence of the jury, this is read out in his presence. And in his presence, the judge is saying to everybody at line 37, Dr. Puri quotes the sections of section 22A. So he quotes it in his report. I don't see anything wrong with those being outlined to the doctor, because that's obviously, he has to point out that it's a mental abnormality, and then he has to go into the impair and substantial impair aspect. So the experts, they're listening to that. What on earth does the expert think the judge is talking about? He's saying to the expert and everybody in court, in the absence of the jury, the expert's got to do with mental abnormality, and then he's got to go into the impair and substantial impair aspect. So I really don't understand, with the greatest of respect to my learned friend, what other interpretation the Deemster or the appeal court was meant to make of what was happening there. I mean, it's been spelt out to an experienced witness why the jury's been taken out and what has to happen when they all go back into court. And so that's the background to what then happens. And then the advantage the trial judge has got, which I don't have, and indeed my lords don't have, and indeed my learned friend who is for the appellant doesn't have, is that we're not there at trial. We're not seeing the way that the witness is answering the question. The judge is. The judge is looking at the witness. The witness is an experienced witness, has been told in the absence of the jury, this is why you're here. Then in the presence of the jury says what we see at page 933, if I could just take us back to it. At line 31. Now, this isn't a witness saying, an experienced witness saying to the judge, could I raise a matter with you, Your Honour, sir, in the absence of the jury. It's not a witness saying, I've heard what you just said in the absence of the jury. Could I just clarify that I'm allowed to go on and talk about substantial impairment? He's not raising that. The judge has told him he can. He's not raising that. In fact, what he's saying is the ultimate issue in this particular case, I'm not going to comment on. I'm going to leave that to the jury. I will lead the jury up to the water. I will show them that, in my view, it's serious. I will tell them there's a direct link. I will tell them that it's pervasive, in my opinion, but I'm going to leave it to them to make that decision. What is the judge who's looking at the witness? What is he to think? Well, he's entitled to form an opinion about that, because that's why he's the judge of the issue. He's there seated to make that, and he made the decision that, having had the witness in chambers in the absence of the jury dealing with this matter, the witness, for whatever reason, had decided not himself to use those words, substantial impairment. Now, what does defence counsel do? I'm sure that at least once in our professional careers, we have all come across a situation where an expert doesn't come up to proof. But when an expert doesn't come up to proof and you are a defence advocate, you have two choices. You either press the expert with the risk that your defence completely goes, because for whatever reason, the expert has changed their opinion. It may very well be that in the process of looking at what Professor Shaw has had to say or rethinking about it, the expert has said, I'm going to be cautious. I will lead the jury up to what I think the position is, but I'm not going to use those words. We've all had it. So defence counsel has two options. One is they can run the risk of pressing their expert on that matter and the defence completely falls apart. The other option is just to leave it and think, I've got enough. I've got the expert saying there's a direct link. I've got the expert saying it's a severe illness. I've got the expert explaining what severe illness means in the context of this case, dealing with why it's pervasive in those 5 areas that I talked about when I addressed the court earlier. And that's what defence counsel did. And the judge took the view that the expert was asked a direct question and didn't wish to give an answer to it. And that happens sometimes in a criminal trial. And so the appeal court faced it that way. Yes, my lord.
But in this case, as we know, the defence counsel asked to recall the witness.
Yes.
And the Deemster knew that, and the Court of Appeal knew that.
Yes.
So how does that fit into your picture?
I think, my lord, my submission is that the Deemster took the view that the witness had deliberately ducked the question. It's a direct question of an experienced witness, and they had ducked the question. And therefore, it would not be fair on the prosecution, because the judge, of course, is not there just for the defence, but also for the prosecution. It would not be fair on the prosecution to allow the defence to have a second bite of the cherry. My lord, I've just lost you volume-wise.
So that may indeed be the case, but the Deemster, also the Court of Appeal, would know that by the time the time the jury was to be addressed, it wasn't a tactical decision not to explore it. On the contrary, the defence counsel felt they made a mistake.
Yes, the defence counsel was under the illusion that they had used the word substantial impairment, when of course the word substantial impairment had not been used. So to that extent, there had been a mistake. However, what my submission is, and what my lords have to look at, is was substantial impairment actually placed in front of the jury? Was the substance of it put? Are we arguing, in other words, are we arguing over labels, or are we arguing over substance? Now, if the position was that before the jury, none of this had been traversed, all the information that the jury needed to make their decision, if none of that had not been placed in front of the jury, then of course we would be arguing about substance and there'll be a real concern. But the only thing that defence counsel didn't do was use those magic words, substantial impairment. So the question for my lords is, in the context of this case, bearing in mind all the substance was put before the jury, does it matter? And if the judge had said, okay, you can recall Dr. Puri, and so the one question that Dr. Puri is asked is the question, well, do you think this was a substantial impairment at the time of killing? And he answers in the affirmative. Does prosecution counsel have to do anything more? She's already cross-examined him on why it's pervasive or not pervasive. She's already cross-examined him on all the issues. She doesn't have to do anything more. Her address to... Yes, my lord.
But could I bring you back to page 929 and line 15 and ask you what the judge meant?
I don't know, my lord, in honesty. It doesn't... whatever the judge meant, it wasn't acted upon, either in the conversation that follows immediately after that, because he goes on to, as my lord can see, he then goes on to deal with the point. I don't understand what it is he is referring to at that point. He says we're in a bubble, and he then said, yes, he and Relic can't give his opinion on them. So I don't know what this means, because if he's saying them, he's saying he can't give his opinion either on there being an abnormality of mental illness or the degree of the mental illness in terms of significant impact. And clearly the judge was not saying that. I do not know what he means at that stage.
Well, could Dr. Perry have been confused?
Yes, he could have been confused, and it may very well be that what the judge then goes on to say, that he's here to give the two matters, the Dr. Puri didn't hear, or was half asleep, or whatever the reason. But the point is, my lord, if he had a concern about it, as an experienced psychiatrist, he would raise that. He would say to the judge, can I raise something in the absence of the jury? Can I seek guidance in the absence of the jury? Because that's what he's there for. And he knows if we accept his witness statement at face value, his recent one, in some jurisdictions, he's allowed to give evidence on the ultimate issue. In other jurisdictions, he's not. So if he's in doubt about the matter, if this is truthful, why hasn't he raised it? Why hasn't he just simply said, I'd like to raise a matter with the court in the absence of the jury?
Mr. Aina, we better let you develop your submissions, because the respondents indented for an hour in the response, and time is running out. Yes. So if you could pull the submissions together, please.
I will, my lord. I have assumed that my lords have read my written submission, so I'm focusing on answering. Yes, the matters.
Yes. You can take it. Your written submission has been read by the board.
I'm grateful.
I didn't want to embarrass you by shutting things down suddenly.
Not at all. Can I do so? In short, the board has to decide whether trial counsel, or indeed the Deemster, did anything wrong in the Deemster's conclusion that the expert just deduct the question as he put. I'm sitting there as a judge. I saw a straightforward question being asked of an experienced witness, and he decided not to go as far as he was entitled to. The last point, please, my lord, that I think I would like to deal with is the section 16 point. The point about expert evidence being admissible by virtue of statute, and therefore what should have happened here is that effectively the witness could have been cross-examined on what was in their report. That's essentially what's being said, because the statute allows that to happen. Well, my lord, as I've set out at in written at page 1537. That with the greatest of respect to my learned friend, I disagree. What normally happens at trial is that the parties identify what the issue is, and a joint statement is put before the jury identifying what the issues are. And so there is no need for a witness to be, the jury to be troubled with lengthy recitation of matters which are not in issue. What happens with the greatest respect is that when you get to the nub of why the expert is there, the expert is allowed to give his evidence in the non-leading fashion so that he can express his own words in whatever way he feels is appropriate. That might be reading the relevant section from his report, or that may be him using different words that convey what's in his report. But I disagree that what you do is you effectively don't ask your expert any questions. You essentially just read out a report and then you sit down. I disagree with that. The issue here for the expert was not the illness, but the effect that the illness had had. And I sought to give an example of why that must be the case. Because if you look at page 1538 of my document, if my learned friend is correct in his interpretation of the statute, it would mean that the prosecution would be under an obligation to agree a section in England, it's section 10 of the Criminal Justice Act, an agreed fact admission about the part of the report that hadn't been adduced, because statute allows that to be placed in front of the jury. That's the effect of what my learned friend is saying. I mean, there would be no need for the expert to be recalled. If he's right, the Crown are under an obligation to agree it, because it's in his report and the statute says it's admissible. So the Crown are under an obligation to agree it as an agreed fact. And with respect, that can't be right in the circumstances of this case. A prosecuting counsel, for all counsel, have a duty to agree matters where there's no dispute, and we frequently do. But we don't agree matters where there is a dispute. So I disagree with the practical way that my learned friend says the law works in this circumstance. One final submission. The purpose of the trial process is so that the tribunal of fact can assess the expert witness. And one of the ways it assesses the expert witness isn't just what the witness says, but the way the witness says what it says. The tribunal of fact can't do that if on the area which is in dispute, it's just put in front of the jury. It's put in front of the jury. Now, my learned friend may respond by saying, well, it's put in front of the jury, but then the Crown can cross-examine on it. But the answer is the Crown did cross-examine on it. As I was repeating the point, they did cross-examine on the whole topic. And the jury had the choice, and the jury decided they weren't persuaded. So, my lord, that's all I wanted to say on the section 16 point.
Could I ask one question, please, Mr.
Yes.
There was nothing, was there, to stop the defence counsel when Dr. Puri gave the unexpected answer that he did, to say, Dr. Puri, on page such and such of your report, you state this. Do you still agree with it? That wouldn't be cross-examination. That would merely be drawing the witness's attention to what he had said.
My lord, I think the answer is that there would have been nothing to stop defence counsel from doing that, but I think prosecuting counsel would have objected, and I think the judge, looking at what has happened in this trial, having seen the witness, might have upheld the objection.
What would the objection be?
That he's already given his evidence.
Well, his evidence was he thought it was a matter for the jury.
Yes.
And what it said was that he had an opinion, and he could, would it not be perfectly open to the defense counsel without amounting to anything like cross-examination, merely to say, well, you've said that there, I mean, do you adhere to it?
The prosecuting counsel would object, saying that he's already given his answer to a direct question. Now, the issue, my lord, would then be, having seen the attitude of the Deemster and what he said, whether he would have upheld that objection or not.
I see. Thank you.
My lord, the question that perhaps might arise is whether defense counsel should have asked for the jury to go out and to raise the matter again in the absence of the jury. That's a different matter. But my respectful submission is that defense counsel couldn't have raised that matter in the presence of the jury, bearing in mind she had already got an answer. So, my lord, the final, I think the final point, which I've set out in some detail from page 1539 and onwards, is the alternative submission, which is that if my lords were of the view that there had been a mistake by defense counsel, the next question would be, does that inevitably lead to the conclusion that the defendant did not have a fair trial? That's back to the legal test. And what I've sought to set out is all of the issues were placed in front of the jury. All of the issues were placed in front of the jury. And I've set out the difficulty with respect that the jury would have had, and why I submit that my lords should not act on page 154 of my lord's papers. There is a heading in the written case statement that deals with overwhelming evidence rejecting diminished responsibility. And my lords, it's quite clear from reading these transcripts that the difficulty that the jury had was that they had a man who it was open for them to simply conclude he was jealous because his wife was having an affair with his best friend and he'd had enough. And prosecuting counsel's cross-examination of the appellant was that on the 30th of November, you deliberately set out to end this. And that's why you did certain things in the way that you did. And what the jury had to consider is that, do we think that that is what has happened? And they were sure that that was what had happened, as opposed to any severe impact of the illness that the defendant had. And so what, my lords, we respectfully submit is that even if there had been an error by defense counsel in this case, the issues that the jury had to deal with, which was the pervasive effect of the illness, the impact of that illness on this man, was placed before the jury. And if there was a retrial, all it would change is the word substantial impairment would be added, but there'd be no further cross-examination, because all the cross-examination on what had actually taken place has already happened. And that's why we respectfully submit that the verdict would be the same. Unless I can assist further, that's all I wish to say.
Mr. Ainer, thank you very much for your submissions. Thank you. Also, Lord Hamlin has a question before you can relax.
Yes, if the appeal was to be allowed, what do you say about retrial?
Well, my lord, yes, my lord, we would submit that there should be a retrial for the reasons I've just set out. That in a retrial, the only difference would be the word substantial impairment. The issue of murder and diminished responsibility would be exactly the same for the jury. It's not, in other words, it's not inevitable in this case that the jury would find a verdict of manslaughter.
Yes, yes. I'd taken that to be your position, Mr. Ainer. Thank you very much. Mr. Wharton.
Thank you, my lord. I can reply in less than 15 minutes. First of all, the elements, in fact, of this defence of diminished responsibility can be distilled into the following we submit. Was there an abnormality of mind? In other words, the personality disorder. That was not in dispute. Was it active? Was it extant at the time? That is not in dispute. It never was in this trial. It certainly wasn't by the end. And that, with respect to Mr. Ainer, deals with his pervasive point. Pervasive is not in issue. It was not in issue. In fact, it is an intrinsic part of a personality disorder that it is pervasive. Once it has formed, it never goes away. As one psychiatrist once described it to me, it's like the ripple in Raspberry Ripple. Did it have an impact on loss of control? That's not in dispute. As I said at the outset, that was not in dispute. All of these features were not in dispute. The one matter that was in dispute was whether the impact it had on loss of self-control was sufficient to fall within the definition of substantial impairment. And so all of the submissions made by my learned friend go to those matters which were not in dispute. That is the cross-examination submissions by Mrs. Watts. What the respondent's argument amounts to, if I understand it correctly, in our submission is this. Mrs. Watts addressed the witness on what was left to be addressed, namely the severity of the disorder. That was all that was left to Miss Jones, having failed to elicit the critical evidence of substantial impairment. And Miss Watts did that by seeking to test and at times challenge how pervasive the disorder was, what impact it had in his everyday life, how severe the disorder was. Those were the only things left to Mrs. Jones. They shouldn't have been, but they were. To say that carefully and circumspectly avoiding the issue of substantial impairment in her cross-examination, on the one hand, is the same as saying she addressed substantial impairment on the other hand, is just to put it like that, is to expose the illogic of that submission. And if there were any doubt about that, which we submit there is not, one only has to return to Mrs. Watts' closing address to the jury at page 1090 to 1091. At line 27 on 1090, you've heard the expert evidence, which you may accept from Dr. Puri and Dr. Bradley, that Mr. Anderson was suffering from a borderline emotional, unstable personality disorder. And then over the page, what she does is she says, the only issue left is whether it's substantial. Top 3 lines. Can they satisfy you? It's a substantial impairment. So Mrs. Watts is making the very point which undermines the submissions the respondent has sought to say show that she was in fact, because she had to, addressing substantial impairment. And that, as we've already shown, on page 1091 is also how the Deemster left it to the jury. But there was no evidence on that element. No expert evidence, I should say. Two brief further points. As for my Lord's reference to page 929 and line 15, this is something that we gave some thought to. And on one view, it is an obvious explanation for why Dr. Puri might have further had his confidence undermined as to whether he was entitled to express a view on substantial. Dr. Puri doesn't in fact say that, we concede, in his witness statement, which is why we left it, as it were. But in reply, we submit we are entitled to say, well, it's entirely possible, having been asked about this a number of years later, that he wouldn't remember exactly why. So we couldn't base our whole case on that, for sure, but it certainly is a feature that on its face does give rise at least to a suspicion that it may have had some impact upon him. And lastly, sorry, there are two brief further points. Penultimately, my learned friend says that Dr. Puri, as an experienced psychiatrist, could and indeed should have raised with the Deemster his doubt. In our submission, that's the job of the legally qualified advocate, not the non-legally qualified expert. And then lastly, as far as section 16 is concerned, the analysis by the respondent in our submission doesn't hold water. Both section 16 and the English equivalent contain, and it's at page 1805 of the bundle, a qualification to the admissibility of the report without leave. That is, at subsection 2, if the author of the report is not to be present, then it is not admissible without leave. And the obvious explanation for that, we submit, is that it deals with admissibility. So the report, once admissible, is not accepted. It hasn't proved its contents, it's simply a question of admissibility. And that is only permissible without leave if the purveyor, the profferer of the opinion, is then there to be cross-examined about it. And if the other side have their own expert, they can put that opinion in exactly the same way, and she or he can be cross-examined about it. So the suggestion that the section would import necessarily that the other party had to accept the content of the report is, in our submission, misconceived. Unless there's a specific matter, my lords, that's our reply.
I don't see any of my colleagues wishing to ask any further questions. The board is grateful to counsel for their clear submissions, and also to those who have assisted counsel in the preparation for this appeal. The matter raised is one of obviously considerable importance to the defendant, and the board will take time to consider what advice it will humbly tender to Her Majesty. The board will now adjourn.